Hi, my name is Chris COsta. I'm an associate attorney at the law firm of Manny Gordon Seller in Tampa, Florida. My specialty is business immigration and specifically investment visas. I've worked with foreign investors for the past 4 years approximately, previously in New York and now here in Tampa, Florida. The second visa we'll discuss is the L-1A visa. This visa, as I mentioned previously, is available to foreign nationals who are either executives or managers of a foreign business entity. This can be an executive or manager of a company or a division within a company if it's a larger company. The foreign national would have to have worked at the foreign entity, which can be the parent company or an affiliate of a newly created U.S. entity for at least 1 year within the previous 3 years. The newly created U.S. entity doesn't even have to be engaging in the same line of business, but it does help if the business is related and if there will be ongoing transactions between the U.S. entity and the foreign entity. The foreign entity would also have to remain in existence throughout the duration of the L-1A visa, which is available for up to 7 years. In the case of what's referred to as a new office, where a newly created U.S. company is established, the visa will initially be appointed for 1 year, which is in a way a provisional time period where the U.S. government will, after approval, decide whether or not this business entity has, let's say, met expectations in a way and become successful. If upon renewal the business does meet these expectations, the visa is renewable for 3 years, twice, for a total of 7 years. So it's renewed twice afterwards. There isn't a minimum investment in this scenario as well, but L1 visas are notoriously difficult to obtain in the case of a new office. And this might be because in the future applicants have an easier path to apply for the green card. There's another visa which we won't discuss at this time called the EB-1C that basically follows the same criteria but on a larger scale. So it's also available to international managers or executives of foreign entities who are currently working in the United States at a subsidiary or affiliate. So for this business visa, in the case of the new office would have to obtain commercial space, would have to purchase inventory, hire employees. Same as for the E2 visa. In all scenarios, the business would have to commence already its operations. And just as in the E2 visa, funds can be transferred from abroad or from the United States as long as their source is verified. This is actually a more important consideration for the E2 visa, but of course, verifying the source of funds is important in general because the government is concerned about criminality, yes, if the funds originate directly or indirectly from criminal means. So, in the case of the L-1A visa, another important consideration is that the employees here in the United States, as well as abroad, are scrutinized a little more heavily, in a sense, just because in order for a foreign national, a visa beneficiary, to be a manager, which is one of the two categories, either manager or executive, the employees have to be professional employees. So a lot of times, let's say, companies that are engaged in sales, general sales, might have more difficult time petitioning for a foreign manager. In that sense, they would have to be petitioning for a foreign executive. And the distinction is that the manager oversees employees principally, and while managing a function actively, and executives are more concerned with developing policy and, let's say, initially creating a roadmap for the company to follow in the future within the next following 6 years after the initial first year of operation.